My name is Glenn Green. I'm part of 3rd District. First of all, I'd like to thank all the board members for the work you've done. I wasn't able to make the last meeting. I do appreciate what the steps you've taken going forward, although I understand there was some opposition there. I want to know that, I want you to understand that the rowdy crowd that you all had to bear witness to do not represent the patients that are here for the serious issue of marijuana, medical marijuana. There are some people here that will hopefully underhear with some agricultural disclaimers you'll hear later. I was hoping that the hospice worker would be here. I didn't see him. I would ask that the board listen to some of the hospice workers, or at least invite them to get the view from the actual cancer patients, the people who need this medicine. I live between a church and a wall, at 75 feet from my house. Ms. Greco came out. She understands my situation. They can look right down in my backyard. My problem is I'm exempt from Proposition 15 no matter what fuss I raise. So that's all I have to say. I appreciate what you have done. I hope that you see into the future. I regret that this is 10 years down the road. I do have to say, if you're my financiers, I'd have hired her. 10 years is too late. Something should have been done sooner. You do have a problem, and I'm glad you recognize it. Thank you, Natalie.
Next item is county departments. Board of Supervisors. Appointed board and public member to the Marysville Redevelopment Agency Oversight Board to take action as approved. Who's doing this?
We're just in receipt of the letter that was addressed to you that's in your packet from the city of Marysville, asking that the board appoint one board member and a public member. I have not done any kind of posting for that public member. I was waiting to get any kind of direction from you as to how you wanted, if the board wanted to handle that. But they are requesting that you appoint at least one board member so that they can, to their redevelopment agency.
Any input from the board on this?
Yeah, I'd be happy to do
That's slot. Everybody agree with that? Okay. You're unanimously appointed John McLeay to the member of the Board of Supervisors. As far as the public members concerned, I think we've got to wait on that. Did you get the word out?
Would you like me? Yes, I can put a vacancy notice out for that committee and ask for applications.
However, our normal rules about the 20 days posting, that does not apply. We're great after time, and they need someone appointed as soon as possible. So as soon as one, if you can put that notice out, that way, and someone comes forward and is appointed as soon as
I have no idea. The only thing I know is by what the letter says, and they don't ask for any terms. I believe it will be that they would serve at the pleasure of the board.
It's just shutting down their office. They need some details.
If I may, Madam Chair, so next, I believe it's next Tuesday. Kevin, are you? Is Kevin here somewhere? Next Tuesday, is that correct?
Yes.
Next Tuesday, we'll be coming forward to the board, also requesting appointments to our successor agency for redevelopment, and we'll explain some of the details there about terms and so forth. So we'll be coming forward to you for a whole slew of appointments that we have to do. There will be from Office of Ed to public appointments and also board members as well. So we'll provide that information in detail for you.
Okay, moving on.
Was there a motion to appoint?
Oh,
I'll make the motion.
Okay,
Motion second.
thank you.
Motion second. All those in favor of John McLean serving on this board? Say aye. Anyone opposed?
Thank you.
Motion carried. Ordinances and public hearings.
If you challenge in court the action or decision of the Eden County Board of Supervisors regarding the zoning, planning, land use, or environmental protection matter made at any public hearing described in this notice, you may be limited to raising only those issues you or someone else raised at such public hearing or in written correspondence delivered to the Eden County Board of Supervisors at or prior to such public hearing. And such public comments will be limited to 3 minutes per individual or group. When you come forward to the microphone, when your name's been called, please state your name and where you are from for the record. Our item is hold public hearing, waive reading, and adopt ordinance adding chapter 7.40, addressing marijuana cultivation as a public nuisance to the Eden County Ordinance Code. This is the second reading.
Mr. Mallon, do you have a statement?
Yes, good evening, Chair, members of the board. Kevin Mallon with Community Development. I just wanted to spend a brief minute or two going, just highlighting what's occurred today. We spent considerable time preparing a presentation when the ordinance was introduced on April 17th. I just wanted to make sure the audience had a brief recap. The ordinance, as written, declares a public nuisance for certain activities, and then creates an exceptions basis through different thresholds where you can be accepted out from being declared a public nuisance. The exceptions basis thresholds are based on parcel size. The ordinance creates what's called a defined area of cultivation, and then by parcel size, the county has created thresholds for parcels that are less than 1 acre, 100 square foot area, defined area of cultivation. The parcels between 1 and 20 acres, a 250 square foot defined area of cultivation, and parcels that are greater than 20 acres in size, a 500 square foot defined area of cultivation. And the county has begun preparing some illustrations of what those defined areas of cultivation and the text of the ordinance means. They were attached to the board's packet, so the board can get a preview of what we're trying to do to help educate the public of the intent of the ordinance. And with that, I'd be happy to answer any questions you have.
Any questions? Yes. Thank you. I'd like to make a brief statement. From my standpoint, this meeting is pretty much a continuation of the meeting of April 17th. At that time, the board passed the first reading of an ordinance to make it a public nuisance to cultivate marijuana under certain circumstances, as Mr. Mallon was alluding to. At that meeting, a number of people objected to that ordinance, said the ordinance was too restrictive. Therefore, our board committee of Mary Jane Grable and John McLean was instructed to continue study of the ordinance and to return to the full board to recommend any changes in the ordinance. We'll let that a little later. As to the content of the meeting tonight, hopefully we do not have a replay of the last session, which would walk us out of control. Again, we want everyone to get a chance to speak. Therefore, we will have a time limit of 3 minutes per speaker. We ask people to speak, to fill out a card located in the back. We won't know about that if you wish to speak. Give your name and your place of residence on the card. When you come forward, please give your name and place of residence and confirm that. I ask the audience to be respectful of speakers and do not carry out a conversation with your neighbor as we've done last time. Last time there was so much noise, general noise in the audience that the speakers could hardly be heard. This board takes this, I can assure you, this board takes this issue seriously. On the one hand, the board needs to take note of over 200 complaints from Newton County residents concerning marijuana cultivation. On the other hand, the board is sympathetic with the wishes of those who need medical marijuana. We are giving this our best shot. Where do we go? Anybody else? Do we have anybody else from this staff of the county to speak? Are we ready for the public hearing? Okay, so we open it to a public hearing, and we will call the, John, we'll call the names of people who have turned in the office.
Steve King.
Steve King, Alderperson. This board is actually leaving itself open for a grand jury investigation and a lovely lawsuit for all these people sitting in this room. I'd like to know how you believe you can vote against state Supreme Court ruling. That's my question. Oh, and that little sign there that says doctor that set the limits? Any doctor that sets the limit is not covered by the federal Supreme Court ruling. Thank you.
Jerry Lake. Oh, I'm sorry, I think that's Jeffrey Lake, I apologize.
Good evening. Thank you very much for having me. My name is Jeffrey Lake. I'm a lawyer. I live in San Diego, California at 11650 Iberia Place. I specialize in medical marijuana law, and I spend a lot of time working with boards such as yours on precisely this issue, and that is balancing the public safety, the nuisance, and the positive economic impacts on one side with the right of safe access to qualified patients on the other. And I'm very grateful to be here, to be a part of this process at this very crucial point for a couple of reasons. First, as I noticed in the ordinance, this board is dedicated to trying to get this ordinance right the first time. And I think that is a very, very good first step. I was in Nevada City last week. I was working with their board. I'm meeting with Sheriff Royal of Nevada County on this Friday to go through the exact same process that we're going through here. And I wanted to just take a few minutes to answer questions if you have them, but to address a few particular points of law that are going to be very critical if this ordinance is passed as currently drafted. And the reason that's important is because I don't think there is anyone in this room that doesn't want to see reasonable regulation of the cultivation of marijuana. Nor is there anyone in this room that wants to go through a long, protracted, unsuccessful, and expensive litigation process. So if we can avoid that and work together to put together a good ordinance, I think that everybody here wins. So I'm not going to dwell on the public policy issues. I'm sure you'll see lots of testimony about that today. I'm not going to talk about the irrelevant issues, of which there are many. I can list them. I'm not going to talk about the federal ramifications of cannabis, but I do want to point out some of the particular issues that are going to have to be addressed if this ordinance is passed in a legal setting. And there are 10. The first is the current state of the law in California, which, as you know, state law preempts local municipal law when it comes to land use and zoning, has to do with the fact that the Lake Forest case is currently good law. And in that case, the 4th District Court of Appeals held that while we conclude local governments may not prohibit medical marijuana dispensaries altogether, cannot be prohibited, with the caveat that the legislature authorized dispensaries only at sites where medical marijuana is collectively or cooperatively cultivated. Thus, and this is the important part of this holding, the legislature has determined the activities it authorized at collective and cooperative cultivation sites, that's what we're talking about here, including a dispensary function, which is really just a distribution of cannabis by and among the members to themselves, does not constitute a nuisance. So if a nuisance statute is enacted in violation of Lake Forest, it will be preempted by state law, and therefore it would be held illegal and unenforceable. And as long as Lake Forest is good law, the current ordinance is drafted, is going to be preempted, and is not going to be enforceable. That's number one. Number two, and this is important too, SB 420.
Excuse me, we're holding people to the time limit this time.
I'll give you my 3 minutes.
No, it's okay.
So everybody-
I'm going as quickly as I can, and like I said, I'll make myself available to anyone, anytime, and we'll take as much time as we need to get this right. I'm dedicated to that, but I did want to point out a couple important legal points. Next is, as you know, Senate Bill 420 has been codified in the Health and Safety Code in section 11362.775. And in that provision, it says specifically that persons, qualified patients, who associate within the state of California in order to collectively or cooperatively cultivate marijuana for medical purposes cannot be subjected solely on that basis to any criminal prosecution under the statutes that set that forth. What that means is that the collective, cooperative process in cultivation is an important aspect of SB 420. There are individual rights and there are collective rights. And the way this ordinance is currently drafted, it ignores those collective rights because patients are allowed to work together to cultivate. And we need to keep that in mind the way this is drafted. You can't ignore that part. Next, you have to look at the restrictions.
How long is this going to take?
I'll be done in 3 minutes, but I'm happy to.
You've already had 3 minutes.
I have, okay. Then I'll conclude. There are many reasons why this ordinance is drafted. I think it's subject to legal scrutiny and it could be challenged and found unenforceable in a way. What we're trying to do is avoid that, to put together what I think everyone here wants. So I would urge this board to take the time to do it right now. And if it means more public input, seeing what happens in the courts, working with the other counties that are trying to do the same thing, or with all the stakeholders, I would urge you and implore you to please consider that very seriously, even if it takes a little longer than having to go through a very long and expensive litigation process, because that is not going to be to the benefit of anyone. So if there's any questions, by all means, I'm happy to answer them now. If not, like I said, I'm happy to work with everyone here. But mostly, thank you for your time and for your patience to challenge this very difficult and important issue. Thank you.
Jonathan Feingold.
Chairman, other members of the board, thank you for having me here. I'm Jonathan Feingold, resident of Moonshine Road in District 5. And I'm an attorney representing county homeowners and other residents who are patients and caregivers cultivating medical cannabis. And my neighbors and clients are really concerned about this ordinance. They're all law-abiding people, and they're concerned that they're being criminalized by an ordinance that is really going further than is needed to regulate the cultivation of cannabis. I think most people will agree that some regulation is needed, but we don't believe this ordinance is the way to do it. The primary issues that my neighbors and clients have are what seem to be unreasonable restrictions on the square footage that is available to cultivate cannabis. And secondly, the fact this ordinance makes no provision for collective cultivation. And as Mr. Lake pointed out, California state law, Health and Safety Code 11362.775 specifically permits collective cultivation of cannabis. It's been upheld in the Lake Forest decision, and that's the law. So we think that should be abided by. Just a few more points. Now, this ordinance is designed to address a big nuisance. And the ordinance says that it's enacted to avoid the risks of criminal activity, degradation of the natural environment, malodorous smells, and indoor electrical fire hazards, 4 issues. These are all valid concerns and they need to be addressed. But we believe that this ordinance is really unnecessary to address these issues. There may be issues that are needed to be addressed, like how close a cultivation site can be to a school. That can be done through zoning. Now, taking up these issues, for example, criminal activity. If there's criminal activity going on at a cultivation site, there are plenty of state laws, county ordinances to address that. And if the cannabis is being grown in a manner that's in violation of state law, Health and Safety Code 11570 and Civil Code 3479 address that directly. Degradation of the natural environment, the second point. Now, there's nothing in the ordinance that really explains what that's about or how this ordinance is going to help. But there's, again, there are plenty of laws and ordinances already in existence to deal with that. Malodorous smells, third item. Okay, so if bad odor is objectionable to a considerable number of people, Yuba County Ordinance Code already provides a remedy, section 736, 310, 810, defines a nuisance as anything that is indecent or offensive to the senses, et cetera, et cetera. So there's already something to deal with that. Indoor fire hazards, you've got a building code. So I think if the board can step back for a minute and allow a good ordinance that people can get behind to be passed, that's would make everything happen. Thanks for your time.
Mrs. Matlock?
Hello. I'm reading this.
Your name and place of residence?
Tina, the mayor of Yuba City's rental house in Marysville. I'm here on behalf of my son. I'm sorry, I'm school in Yuba County Jail. Sorry. For marijuana sales. This charge seems false allegations based on statements and accusations from the Net 5 agent, Brandon Spears. My son wrote me this story on his behalf. My name is Christopher Matlock. I am a medical marijuana patient with the doctor's prescribed to use marijuana and grow marijuana. I also am a caregiver for a few friends. In 2011, I had a small garden with about 25 plants for 4 of us. Some of you might have heard of a robbery that took place September 29, 2011, when an armed gunman entered my secure garden area and I confronted them. When I fled, giving them chase, which one suspect jumped in his SUV and got in my car. I got in my car and I chased him throughout much of the window, in which the suspect ran his SUV into a car where a Yuba County Sheriff officer picked up the chase and on Hamilton Smartsville Road. The suspect ended up crashing into an innocent lady. Soon after this is when Yuba County started talking about banning outdoor grilling. With this came Yuba County Growers Association home. On November 10, 2011, Yuba County SWAT and Net 5 broke down my front door and brought me and locked me up in Yuba County Jail. When I received my police report, it stated I only had one prescription. Believe me, I'm not into doing that, but for medical reasons, why he had 4 scripts there, and they're saying that he only had 1. Given that note, they contacted the people I was caring for, and I filled one of the agents that was at my house on November 10, 2011. The other scripts indicated to obtain charges against me. This was at a point in the time Net 5 was losing funding. Also, Detective Frank Knight did the robbery investigation and seen the scripts for himself. They found my grow room 100% legal, and yet he too stated he had only seen 1 script after they arrested him. This time of the corrections, and happened to me, can also happen to you. I wish I could give you the full story myself, but thanks to all the corruption in Yuba County, I am unable to do it. My request to you and to the people is to make a stand and fully fight for our rights. And most important about my case, please feel free to contact me. I'm in Yuba County Jail, and again, my name is Christopher Matlock. Please make a stand and don't tell this down. We can't. We need this for the people given our cherish and our rights. Thank you. And God bless.
Lee Ballard.
I have a flyer that I hand out to you guys that in Long Beach, the pot ordinance is really illegal. Please bear with me, I'm a slow reader, so if I go past my time, please give me that respect, because I'm very nervous up here. First of all, I would like to apologize for being loud at the last meeting. I believe it is important for you to know that no matter how we voice our reasons, cannabis helps everyone. I know that it helps me calm down. My problems come from a few different areas. They range from PTSD to previous head injuries causing concussions, and headaches to pain from compound fracture in one of my vertebrae, and nerve damage from a surgery. Mostly I have pain in my neck from a car crash in April 2011. But most of all, it helps me sleep. I can say in a month, when my pain is at its highest, I can need more cannabis to help me with my problems. I also suffer from depression. My doctor and I have talked about, and he understands that I need more from my ongoing long-term problems. The Supreme Court set a guidelines for patients, but as my doctor states, I need more for my medical needs. You have no right to put a limit on my medical needs, as only my doctor can set a limit on my medical needs, as it clearly states in SB 420, which allows up to 99 plants. I have no need for 99 plants, but 25 plants should last all year long for my needs. There are many things that you have put ordinances on, and I don't see anything done about them. Due to injuries, I won't be able to have my medicine because being on SSA from surgery that caused nerve damage and being on state income, I can't afford to get it from a dispensary. You are in violation of my civil rights, and other cities and counties have set ordinances and have been overturned by the Supreme Court. But most of all, you are going to leave me without enough medicine to last all year, and the cost of indoor would be too much for me to grow my medicine. That is why I need an outdoor light. And to save our county from a lawsuit, which our county is below the standard of other places, and can't afford to lose the money that it will take to pay for the lawsuit when you lose. Look at our roads. That shows that there's not enough money. Fix the roads and other things. Excuse me. That would suffer, like education or even a bigger problem. The meth use around here. You're spending more time trying to take our civil rights away than trying to get help to others who are in the low points of their lives. Thank you.
Michael McCauley.
Good afternoon, board members. Thank you for your time.
Your name and place of residence, please.
My name is Michael McCauley. I'm a resident of Sacramento County. I'm a cannabis specialty crop consultant, as well as other crops. I have an agricultural background. I've been working with some of the patients in your community. Some patients can't be here. Some are sick and disabled. They have concerns. I'd like to echo Mr. Lake's statement and commend you folks for taking this ordinance seriously and getting it right the first time. I heard that there were some ad hoc committees that were supposed to happen since this last meeting. I don't believe it happened. I would like to encourage you folks to have those meetings and maybe even form a commission that has some public input. I have a question for you folks. Is you County the right farm county? Okay, thank you very much. I believe everyone has a signature on record stating that the residents have to put up with noise, odor, which I believe this is the main contention of this ordinance, saying that the smell is what's affecting this. We can't tell the farmers next door to tell their cows to go away because they're, manure smell. It's just simple facts. This day and age, we can insure our crop. For instance, that gentleman that had a situation with law enforcement, we just need to look at this as a real issue. And I encourage you folks to have a commission and to further these meetings and to adopt the collective and cooperatives that are written in Proposition 215, which is the intent of the legislature and the law that we have. There's people that we've lost in this community that have stood up and voiced their concerns. And it's painful to see these people to deal with their loss. It's a very real issue, and it's a big issue. And I think you folks, it's your duty to protect the health and safety of your constituents, being board members, and I would like to encourage you to do that. Thank you very much.
Kathy Teelan.
Maybe you could call the next one too, and have them take some time.
After Ms. Teelan will be Curtis Allen and then Carolyn McCall.
I'd like to thank all of you for listening to us. I know you've listened to me probably more than you want to. This has been a very eye-opening experience for me. I've lived here for 8 years now. I have grown in Yuba County for 8 years. And I've never, in 52 years of my life, been arrested or gone to jail. I don't intend on being arrested. I don't intend on having my home broken into. I also do not intend on going back and being addicted to drugs. Due to an injury that I had, I was addicted to Norco, Soma, Ambien, OxyContin. I was a doctor shopper. When I got off of those and I went to medical marijuana, I don't doctor shop anymore. I grow my own medicine. I have been to the doctor one time in 2 years. I'm blessed. The thing that concerns me right now, I keep looking at this ordinance and I keep wondering, what about this makes no sense to me? Then I figured, we all overlook things. One of the things that bothers me is Article 11, Section 7, and which is the authority that this ordinance is written on, states that it cannot be in conflict with general law. I'm not a lawyer, but this is how deep I've had to go into this. As of right now, we are in conflict. In January 10th, the Supreme Court ruled that the limits of SB 420 are unconstitutional. Fall plants, that's unconstitutional. That would be like a doctor prescribing 100 OxyContins to someone going to a pharmacist, and the pharmacist going, oh, I'm sorry, they passed the ordinance, you can only have 50 now. And Health and Safety Code 13 or 11365.5 is the Capacity and Use Act, and that says that it has to be consistent with the patient's current medical needs. Your limits are not consistent with my needs. The California District Court of Appeals in July of 2009 said that patients may selectively cultivate. I selectively cultivate. I've told you that. And I do that so that there are people that live in town that are not growing in their backyards. They're protecting themselves. That way, we're collectively growing, we're collectively helping each other. Those are 3 items right there that go against the authority that we're saying you have. Another one is questioning the authority. In 11365.83C, that is addressing co-ops and collectives. Our ordinance does not address co-ops and collectives, which is the one thing that we have asked to be put in there. I don't want you at my house. My neighbors are fine. My neighbors have been fine for 8 years. What you're doing is you're gonna make me do one or two things. You're gonna turn me into a criminal, or we're gonna work through this and make it work. It can happen. I appreciate all of you. I do. Hal Stocker is my representative. This gentleman will take the time to speak to me on the phone. I have encouraged people to talk. Mary Jane has taken the time to speak to me on the phone. We have met with Mr. Backwest, and I have met with Ron. I'm comfortable with my supervisors. I'm comfortable with my county. And I believe that we'll do it right, and we will set examples for other cities and counties in California. Thank you so much.
Curtis Allen.
My name is Chris Allen, resident of Walters, homeowner. Been a medical marijuana patient for 10 years or more. In my personal experience, 10 by 10 is just not big enough area for to grow 6 plants without having crowding and mold issues and other problems. Another thing would be, I don't see how you guys have the right to say that if 2 people reside in a house together, man and wife, whatever, both medical marijuana patients, that one of them is not allowed to grow because only one is allowed. So I believe that everybody with a prescription should have the right to cultivate their own medicine. And that's pretty much all I've got to say.
Carolyn McCall, and then David Lincoln.
Carolyn McCall, I'm from the Dobbins area, and I'm pretty much hitting on the same things everybody else is, but the square footage of this ordinance is not sufficient. Patients using medical marijuana must have mold-free medicine. Under the proposed footage, there will be no airspace for that mold. The canopy of one outdoor marijuana plant is approximately, give or take, 64 square feet. That plant also needs a minimum of 5 to 6 additional feet between it for air. Like an orchard, should be planted on approximately 12 to 16-foot centers. Regarding collectives, there are too many patients in cities that simply cannot grow in their apartments and houses. Rural collectives need to be addressed in this ordinance, keeping in mind square footage needs for healthy, mold-free medicine. I'm currently a caregiver for 2 patients with AIDS, 1 patient with glaucoma, and 1 with hepatitis C, who's currently on aggressive interferon treatments. They need organic, mold-free medicine. I have more than 140 acres. These limitations are ridiculous.
David Lincoln, and then Eddie Miller, or Edie Miller, I'm sorry.
Your name is?
David Lincoln. I reside in Penn Valley, California. I'm a local civil engineer, and I work in Yuba, Placer, and Nevada County. I've been operating as a civil engineer in this area for about 45 years. We have experienced many ups and downs in the economy over the years. We do not render any opinion on the use of marijuana, but obviously it is used for medical purposes by many. There is a fact, though, that about 30% of our business in 2011, from the closest we can tell, was a result of working for medical marijuana people, collectives in particular. What we provided for these people was surveying, grading plans, erosion control plans, soil testing, structural engineering, preparation of building plans. These were responsible growers who did it right. The bottom line is that if we pass a very restrictive ordinance that is not workable for the people that grow medical marijuana, it is going to impact
not only our business, but many more businesses in the community. If this marijuana is useful to people and it is sold to collectives or sold to dispensaries, personally, I don't use marijuana, but I don't understand the big problem with it. I also do not understand why we don't push some of these growers out into the large parcels in the country and let them grow where they do not bother their neighbors. They're not seen from the highway. I'm talking 50, 80 acre parcels that I have seen cooperatives grow on. And it seems to me that solves a lot of problems. It bunches a bunch of medical marijuana patients or caregivers into an area that doesn't bother anybody. And the way you avoid that causing a problem is you charge a $5,000 or $6,000 cleanup fee up front, and you make sure that they clean everything up or they don't get their deposit back. It seems to work fine. For the last month or so, when the plants are ready, I don't see a problem with a self-contained RV or trailer being on the property so that no crime occurs and they can protect their crop. Thank you very much.
Good evening. My name is Edie Miller. I live in Nevada County actually, but I am a realtor. I work for Gateway Real Estate, and I serve actually a number of landlords in Yuba County as well. I'd like to say that first of all, I was not always a fan of Prop 215. As a matter of fact, I voted against it. But when it was voted into law, it was, I am a realtor. I take an oath with the state of California that I will not discriminate in housing. So in working property management, one of the things that I was forced to do was actually get to know this demographic. That at first, when they told me that they were growing marijuana, it brought up all of my stereotypes and knee-jerk reactions and my prejudices. And what I realized was when I was leading with those prejudices, I was not serving my community. I was not serving my position. I wasn't serving what I made an oath for. And so what I learned was that I could put together a screening process that would help me to weed through those that would be good candidates and those that would not. And essentially what I'm looking for are tenants that are prepared to be responsible to the industry, responsible to the home that they're staying in, and responsible to the neighborhoods that they're in as well. And what I discovered is that, actually, I have about 12.5 rentals that I represent in which we do have growers in the homes. I have had one very negative situation in which I had a young gentleman in a house that was just too immature for the level of responsibility that Prop 215 represented. Even though he was 28 years old, he left the home, allowed a friend to stay there, had a wild party, was belligerent with the neighbors. Well, that to me it is a public nuisance and not something that we should be standing for in terms of how we represent the industry. So, candidate B, who was not who we wanted, was asked to leave the home, and everybody else, has been performing at an extremely high level. They're very responsible individuals. They gave me their most personal financial information that I use for screening, tax returns, their W-2s, their bank statements. So those who screened very weak, we were able to stack up their security deposits in accordance with the laws of the state of California in terms of providing a larger deposit to provide additional security. And it seems to me that we don't need one more rule for these growers that require the medical cannabis. There's plenty of rules already in place to be able to support where the securities need to lie. It seems to me that there is a little bit more need for for response from within the community even, in which we can police these issues where bad growers are allowing to put, this few 5% are being able to cast an umbrella and a shadow on the entire demographic of growers. And that just, that's not an appropriate way to handle my position as a realtor. It's not an appropriate thing to do for just a responsible citizen in the community. So, anyway.
Stephen J. Cox and Jason Handy. Jason Handy, and then Carmel Garcia.
Thank you. I was preparing my notes. So I'd first like to just say something about the res ag zoning. When I bought the property that I live on, I was told that I needed to deal with smells and sights and the sounds of agriculture, which I do. The horses neigh, my neighbors make a lot of noise, the chickens smell, and I put up with that. I currently grow for myself and a collective. 2 members of my family actually have medical conditions that respond well to medical marijuana. None of my family and I like to get stoned, and so we look for strains that have low THC and are higher in other compounds like CBD, which is really good for certain medical conditions, pain, and it doesn't mess up your head. These plants tend to be sativas, which grow much bigger, much taller, wider, and they take up more space. While I have been exploring different strains, there's different ones that I like for different times of the day or when I have a different task. Or if I'm in a lot of pain, I'll do the one that's stony because I'm at home and I can go to bed. But I don't understand how I will be able to maintain these different strains and find out what the best medicine is if I'm restricted to having so many strains. I can have some outside, but I can't maintain the mothers because I have only 12 I can have. And if I want to be able to breed them, I have to have them all in this little space, and they're going to all intermix, and I won't be able to keep them true. So having spaces that are separated from each other is really helpful in that. I've been having a condition that is tremors and dysphoria that's maybe pre-Parkinson's, and there's been research done on a certain cannabinoid that is present in African strains that have just showed up here and really effective in stopping those symptoms. And those are sativas as well. I really don't want to be restricted with space and not be able to read and take care of these conditions. My mother uses medical cannabis and she really can't stand the short compact stuff that gets you really stoned. That's what we're going to be forced to grow if we have these rules. So, thanks.
Carmel Garcia and then Lou Neal.
Thank you for hearing this. First of all, I want to just mention, I don't know if you saw the news today, but Connecticut has now legalized marijuana and we've now become the 17th state to do so. Their state is going to be growing it and dispensing it in pharmacies. So now you've got a state that's going against federal law. We'll see how that plays out. But here in our own county, everybody has already pretty well said what I wanted to say, and this is a big issue and one that we should be dealing with. And I'm glad that our person attorneys that came here today. I'm ashamed to say, Mary Jane, that while it was a good idea to have an ad hoc committee and to have interested groups, people be invited to join in, I only heard of one person that attended these ad hoc committees, and it was a grower. A grower does not represent me. He is not my doctor, and he is not my lawyer. This grower can only tell you how to grow. He cannot tell you the law. He cannot tell you what I have. He cannot tell you how much and what I need. And I find that very offensive, and I find it very shameful that you put together this pretense of an ad hoc, and all we've done is spun our wheels. And really, from the first to the second ordinance, you've really done nothing but made it worse. So I'm very, very disappointed in that. I listen to these attorneys over here. I did send you hundreds of emails of doctors and lawyers that are ready to hear you, to talk to you, to answer your questions, and you chose not to. And I'm glad that these gentlemen were here. I'm so glad that they're here. Thank you.
My name is Luke Neal. I'm a retired court reporter, 34 years. I've never been arrested, but I'm looking forward to it. Since the last meeting of the board, the ad hoc committee was selected to address two issues: collective cultivation and how nuisance complaints are made. Can you tell us what was discussed or what was done, if anything? We have no idea. We know a little bit about what she just said, but we are really in the dark, and I'm not big about being in the dark. We got 2.5 minutes. I would really like a response.
I'll go with that then. And we, at the last meeting, asked for a little more time so we could take up these two issues. Unfortunately, I was scheduled to go out of town. That didn't happen. My intent today is to ask the chairman to continue the ad hoc committee in regards to those issues. And so that's, I hope that answers your question.
I would like some responsible growing medical marijuana growers on your ad hoc committee. I'm not saying who, but I would like more transparency. Because we have issues at stake here. If I'm going to be put in orange, I need to have input.
I don't have any more cards, Mr. Chair.
Maybe.
My mother has one.
I would like to talk.
Anybody else?
Please state your name.
Sharon Garrison, 7258 Michelle Lane, Brownstown. I've had one speeding ticket in my life. I've never been arrested. I'm not a criminal. But I feel like this is labeling us all criminals. That, you know, talking to people, exactly what to do and how to do it. And if there are people creating problems, then address those problems. I feel, my son was saying that the types, I don't like to get stoned. I prefer, if I use marijuana, to get as little stone from it as possible. I just want the pain relief, the anti-anxiety effects that it has for me. And he was talking about how those types grow bigger and stronger. And another thing he didn't mention about himself is that the medical condition he has where he gets tremors and stuff, most pharmaceutical medications worsen that. And the side effects of some of those could make it permanent, where he has tremors all the time and they never go away. He uses those pharmaceutical medications instead of marijuana to control it. And to me, that's really important because I don't want to see that happen. Thank you.
Andy Walker.
Hello, I'm Ms. Walker. For one thing, you guys are trying to get us to grow indoors, and we all have kids. Of course, we don't want to put our kids in danger. Yeah, they can jump over our fence, but that ain't put my baby in danger, right? You guys are saying we can't grow together, so that means they can't grow with my mom. So obviously, gotta grow on top of the kid. You know, there's old people that need to, you see this room's full of them. You had somewhere to go, but we don't like it. We really do. So that's it.
Bill Wharton.
My name's Bill Roden, I live in Olivers. You know, it's funny to me is I can go and I can serve my country in Operation Desert Storm and come back with all sorts of neurological issues and then have other problems and end up in pain and having to deal with this wheelchair. And I try to follow every law to the letter of the law. And I work at the collective with my brother and some other people that are patients and try to maintain my medicine. I'm not a nuisance to anybody, and I personally resent the ordinance saying that we are a nuisance. Instead of trying to pass an ordinance that we are a nuisance, why can't we come to some sort of an agreement where you come and talk to us and work with something that we can maybe cut down the odor so that neighbors don't complain as much, like putting a greenhouse top over a garden or something. There's no willingness to budge. You guys want to force a dictator law down our throats, and it's not fair, and it won't fly.
Ivan Pack.
I'm Doug Pack, and I'm a homeowner resident of Olivers. And I just wanted to touch on the one topic again. There was over approximately 200 complaints, but yet you can ask the sheriff, there was not one conviction or violation.
I got a neighbor that is an alcoholic, that's nuisance.
Thank you for your time. I really appreciate this. I know this is a hard topic of discussion, balance between taking care of all of people's rights. I have been growing cannabis for many years and I've never had a complaint. I've never been called a nuisance. I've never had a problem with the law. I moved out in the middle of nowhere and the only complaints maybe might be from the bears from the smell. I'm, in Camptonville area, and there's really not a lot of neighborhoods or anything, so I don't feel like it's causing a problem with city ordinances or anything like that. I don't want to repeat things that people have already said, because clearly there's lots of evidence, and if this ordinance passes, it would violate our rights, the Constitution, which I'm an American citizen. I'm tired of getting my rights taken away of the Constitution. Thank you very much. And one medical fact that I just wanted to bring up is the benefits of juicing the leaves. There's a book of evidence that shows that if you juice the leaves of a plant, and it doesn't have any THC in it, but the live juice is what heals people from cancer, and it's basically just killed a lot of people just from drinking the juice. The plant itself has so many medicinal benefits to it. There's many different forms that can come in. Most people who have medical don't even smoke it. They use it in the form of salves and tinctures and vaporizers. And so I really want you to just try to take all things into consideration. I really strongly urge you not to vote in support of the ordinance, because I personally, it's given me a lot of anxiety, because I've never had a problem with the law, and I feel like people turn good people into lawbreakers, and we're not lawbreakers. We're doing things responsibly. Maybe there needs to be, some sort of regulation, but that's what the state law is for. That's what we want. We want to go with what the state has already agreed to let us do, and to try to go against the Constitution and violate our rights is an infringement. And so I really urge you to vote no. Thank you.
Tabitha Burleson.
Thank you. My name is Tabitha. I'm from Oliver.
do not smoke marijuana, never have. I do not have a medicinal card. I am a healthcare worker. I work at a level 3 trauma center. And I, honestly, what the cases I see day to day is from, people being killed from drinking and driving, teenagers, people old and young, which you can buy legally over the counter at our local stores. Narcotics, which you can get from a pharmacy, prescribed by your doctor. And also as far as the smell, odor, tobacco. I mean, secondhand smoke is medically proven to have health harmful effects on people just breathing it that don't smoke tobacco, let alone the people that do. Where was I going with this? I'm sorry, I'm just kind of nervous here. But as far as it being a nuisance, there's other things that are out there on our market that you can get legally that is a nuisance, drinking, tobacco, no pun intended to the people that smoke cigarettes, but those are all things you can buy legally. And I don't see, and I have never really seen a case at work where, somebody's come in, killed by someone who's smoked marijuana or had marijuana in their system. It's always alcohol, meth, drugs, that kind of thing. As far as the odor, is it medically proven that the odor is killing people or having a harmful effect on people? No, it's not. Tobacco and medicine, yes, it is medically proven. And so I'd like to continue and tell you, none of us have been through medical school, so who are we to judge or tell a doctor he can't prescribe his patient's medication? I mean, what science or what training do you guys know that can, have, I don't know, doctors are doctors for a reason. They go to school for 10 plus years. And so how can you guys sit up there and say that this is a harmful thing, it's a nuisance, it's this and that, when you guys have no evidence proving otherwise, other than the people that you bust and throw in county jail? But that's not all the people in the room. There are responsible people out there. And thank you for your time.
Hi, my name is Paula Miller and I live in Canterville. What disturbs me is that I have spent my life being a law-abiding citizen. I have never broken the law, I have never gone to jail, and I am a community member. What troubles me about this is that when I read it, that we would have to register our grows and then be open to having the police, the code, and whatever other enforcement agencies to our land, to our property. Now that is, I believe constitutionally unacceptable because you're invading my right to privacy. You're treating me like a criminal. And I haven't ever done anything to be treated like a criminal. So I think that this ruling or this ordinance is unconstitutional, and I don't think you're going to get away with it. And that's all I have to say. Thank you.
Through the chair, I just want to, just so that you're not misinformed, it's Yuba City that's doing the registration, not Yuba County. Or that's not part of our requirement.
What about the helicopters that fly over?
I'm from Winnetka, Randy Road.
I would point out that anyone that buys property in Yuba County, in the rural Yuba County, you have to sign a paper saying that the odors and everything, all that nuisance, that you have to accept it as is.
My name is Jim Phipps, I'm from Maryville. What I hear today is we're worried about the smell. If we're gonna pass an ordinance for smell, we should get rid of the sewer systems, the garbage cans, the garbage facility out here that smells. The county should take care of their own smell before asking these people to do the same.
Thank you. My name is Andy Guerra. I'm a resident of Douglas, California, at Dixon Road. I'd like to take a moment to thank Mr. Lake for being here and your social. Thank you very much, sir. I'm concerned that if this board adopts an ordinance that doesn't correspond with California state law, that they may be setting up themselves for potential lawsuits. Butte County is not a very prosperous county in comparison to some, and I feel that potentially jeopardizing the taxpayers' funds like that wouldn't be a good thing. I would strongly encourage you to speak to Mr. Lake and his associates, maybe have him help you with legal aspects of drawing up the ordinance. I've heard he's very good. Thank you.
Carol Cornea.
Carol Cornejo, I'm from Oregon House. I'm going to be nervous. I didn't plan on doing this, but I raised 3 sons very much against drugs, and I think I did a good job. But as time's gone on and I got older, I've become really having a lot of medical problems. My sons had to put me in a hospital to get me off drugs because my doctor had me on so many drugs, Oxycontin, morphine, everything you could think of. I was just totally out of it. And so they had me admitted and I had to stay in the rest home. And they got me off the drugs. And now they've got me down to marijuana and I can handle it. I don't feel I'm a drug addict, and I don't want to be treated as a drug addict. I don't want to go back to a hospital, but I don't want to be arrested for something I think I'm doing to try to help everyone. My sons understand this, my doctor understands it. I don't understand why you don't understand. Yes.
If there's no further discussion, then I'll go ahead and make a motion to close the public hearing.
I have one question. How much money is the board willing to spend on this issue?
If you have a question, please come to the microphone so it can be recorded. And I think this is the last comment because we actually closed the public hearing.
All right, I'm Ivan Pack from Oliver's, as I stated before. And I was just wondering, to the board, how much money are you guys willing to spend on something that is already in effect? To override it, to crush it, whatever. How much of our tax dollars are going to be wasted?
Especially when 90% sounds on both ends.
when, like I said, there was 200 complaints and not one violation. And now we're on the verge of spending thousands and thousands of dollars that have to come from somewhere. I don't want my tax dollars going for this. I mean, it was put to the people to be voted in. And it was voted in as a majority rules. And now, it seems that it's going to be totally opposite. The few will control the many.
We'll take that into consideration.
Well, I'm Aaron Waymeyer from Utah County, and I've been smoking weed since I was 12. I've never been in trouble with the law. I graduated recently last year, and now recently I just got a job and to get this job I had to quit smoking weed, of course, and I started smoking spice. Spice is named after so many different types of weeds, like white rhino, kryptonite, tons of different types. And this spice has infected me in a lot of ways, like especially like heroin. It does something to me like heroin. And it just like puts you out of your mind pretty much. And this is a lot of people who've been smoking this to get a job and get into the Air Force and do what they have to do. And to me, I quit smoking weed and started smoking spice, which I got addicted off the spice. And now I'm having trouble quitting spice. And it's not for human consumption, of course, but why if it's not for human consumption, why they name it after so many different types of weeds, like white rhino and kryptonite, etc. That's what I have to say.
Dan Sullivan. I'd just like to say, if this ordinance is passed, this is unprecedented. At all these hearings, I have not yet heard one person speak in favor of this ordinance. This is unprecedented if it passes. Thank you.
All those in favor say aye.
There's someone else who wants to speak.
Anybody?
There's over here, someone who wants to speak.
Public hearing.
If you have not spoken,
The public hearing is closed. Folks, please. Everybody's had a chance to speak.
I haven't had a chance. And could I please have a quick moment of your time? Just a quick moment, please?
Okay, come on.
Thank you. I'm a patient, but I've been a patient of medical care for longer than 20 years, of strong medication that no longer helps me. And my doctor, my specialist, said for me to try cannabis, and it works. And it works as good as you guys think psych medications work. It works better. But I'm clear-headed. I can be with my family. I can be a better mom. And it's my brain chemistry. It's not a way of life. I'm a patient. I need to be able to get my medicine, but I can't grow it myself. I'm a member of a collective. They are here, not in the city, but they're in the county. I need to be able to have safe access to my medicine so that my collective won't fall apart out of fear. Please, remember there's patience.
We understand. Board of Supervisors, Any comments?
I have a couple short questions, just real quick, if I may.
The public hearing has been closed.
Under the Brown Act, I believe,
Sir, you already spoke once.
yeah, I know, I just had a couple short questions that I left out of my presentation. I just would like to ask one or two quick questions. Ma'am,
This is not a question and answer time, this is time for the board to deliberate.
Okay.
Okay?
So I'm like, can I put one more thing?
Is it something new? I think we've heard,
Yes, it's
we've
something,
heard the
it's
same
something
argument many,
important
many
that I
times.
think.
It's going to be short.
Okay, it is going to be short. It is going to be short, yes, okay. A CEQA Act, Environmental Impact Study. I don't believe one has been done. This is an issue that will be brought up in court if a commission is not formed. I just wanted to have that on record so the attorneys can bring it up if they have to. Hopefully you folks will take the smarter road and bring it before the people and address it properly. Thank you.
What's the board of supervisors have to say?
I guess I'll go ahead and start off. We heard this a few months ago, it was basically a workshop of what the ordinance could be. And so when we heard this item on April 17th, one of the things I talked about was the two issues that were outstanding that I thought were important. That's co-ops and collective issues, and also the complaint-driven. I'm asking that the board, the chair, continue the ad hoc committees to address these issues, because I think they are important. I think the people who sat around the table at the ad hoc felt it was important. So I would ask that the chair continue this ad hoc until the end of the year so that we can meet on these two issues. And just for some historical perspectives, I'd like to talk about what the ad hoc means, because a lot of people have heard that term but really don't understand what that all means. The ad hoc is a member of two boards, and two board members up here. We can't have a majority, we can only have two. And what we do is we specify who we need at that ad hoc. And so one of the speakers talked about, that not everybody could be there, it wasn't transparent. But what I did is I tried to pick out people who I think were representative of the issues. Sam, you represent the Yuba County Growers Association. You have a large membership of 2,000 people. I felt that that was a good indication of everybody out there. We also had individual growers sitting there. We also brought to the table people who are affected by the growing. And I think a lot of you that I've talked to over the months of this issue have said, yeah, there needs to be a little structure because it did get a little out of hand in the neighborhoods. And so I think, when we sat down with the sheriff, the district attorney, our county staff, John and I, we did so in good faith because like a lot of you have mentioned today, I'd rather sit around the table trying to negotiate some balance in the neighborhood than sit in a courtroom and spend a lot of your money and mine. And so I think that was the intent when I could have easily sat on my hands and said, hey, nothing I can do, let's go forward with this and blah, blah, blah. But you know what? That's not how I roll. That's not how I just want to be very clear for those that haven't been at every single meeting that we've been very patient, and I appreciate the good manners today because I think it's really important for this board to hear what you have to say, the message that you're bringing to us. I believe that all parties that we had at the table are interested in coming back to the table and trying to address the issues I think a lot of you have in regards to collective co-ops and how we do the complaint driven. So I think that, sorry I had to work and I had to be out of town, but you know what, I still have to go out, I still have a job to do. And so pulling all these people together is kind of a chore, but we are committed into this program to make sure that we address these issues. And so by no means am I trying to skirt out on this obligation that I've committed to the public. So I just want to be kind of clear on that and where I come from, what my perspective is on this issue, that I am still dedicated to trying to find a balance on this issue. And I know that we can be facing lawsuits. I know that's possible. We can be sued for anything. But the intent was to try to bring some balance to the neighborhood, to try to look at all the issues from all perspectives.
And I think that we almost got there. Thank you.
Any other comments on the board?
Yeah, through the chair. Council, my question is directed to you. I believe there are a number of comments and statements, so forth, talking about the legality, the constitutionality, and so forth of the proposed ordinance. And so my question to you is, as our county council, is the ordinance that we're looking at constitutional? Is it legal? Is it valid? Or not?
No,
Excuse me.
we wouldn't have brought it forward if we had any concerns about its legality. The ordinance is valid, it's legal, doesn't mean anyone can sue you. But suing and winning are two different things. But someone may have a right to possess and to use, doesn't mean that, that you can, the limit you can regard to your land use controls. So the ordinance is valid, and we have no concerns about that. As I said, anyone can sue.
Thank you.
Yeah, I would just I'd take a moment, because I think it's important to understand, because you're not seeing the people that have made the complaints to the sheriff's department, doesn't mean that they're not here. And in the last news reporting of the event we had when we did the first ordinance, those that felt intimidated before pretty much assured themselves they would come into that arena and face it themselves. That doesn't mean that, like you're saying, that they don't have rights.
No one's saying that.
So after the federal government made the statement that they would not enforce those laws a couple of years ago, I remember the moment, I saw it when it came across the television. The growth in Yuba County exploded. So there was an impact. You were noticed. That didn't mean that we hired 1,000 new police officers. That meant that there were just several hundred more gardens immediately everywhere in that next season. You have to know, when anything happens in the community that happens on that scale, there is an impact. There was a response to that. There was a reaction to that. That reaction was listened to. You can't just take that many calls for concern and not deal with it. It's irresponsible. So the effort that was put forward with the district attorney, the sheriff, community development director, code enforcement officers, county council, county administrator. These are our most expensive staff folks that are wrapped up with tremendous amounts of time and energy to try to come up with something that is a recommendation that can address those concerns, because that really is the subject. Nobody called and said, I don't believe anybody with a 215 card should be arrested or taken away because they have a 215 card. That was addressed with the federal statute. Nothing changed about your ability to get a job or not get a job if you test with pot in your system. This doesn't address that. We're not trying to legalize it. That's a much larger conundrum for the state and federal government to figure out. Down here, out here in the small rural communities around here, what we can deal with is neighbors and land use according to a balance for all that. So I'm not opposed to continue to work on this, but I'm not going to ignore the folks that were absolutely concerned and frightened. It was all over the place in a rapid way. So we're going to take everybody's input. Your input has been listened to. And we've been listening with notes. I've got notes everywhere up here. But we're gonna keep dealing with it as far as I'm concerned, and come up with something that we're gonna rest with. And what we rest with is gonna be a beginning. It's not gonna be about legalization, it's not gonna be about whether you should be a 215 card or not. It's just gonna be whether or not we are actually coexisting within our communities. I understand that you guys say that each of your neighbors have no issue with this, but your neighbors have an issue with this. And so they're telling us that, and it's not our business to go out and find problems. We only respond. We don't look for trouble.
One of the things I failed to mention is, I don't know if you made it clear or not, but this is a county ordinance. So the city of Marysville and the city of Wheeling have not adopted this ordinance. They're exempt from this. I know some of the speakers in previous meetings were coming from Marysville and maybe some from Wheeling. And this ordinance does not pertain to those two cities. So I thought I'd clear that up.
We've got all of this.
Yeah, Oliver, Linda, the Foothill communities, they're in the county. The cities are Marysville and Wheeling.
Schumann County is leading to represented by Newton County, the sheriff's out there on your island.
He's assisting me, look out there.
So, county council.
Because they can't pull the cotton out of there and put it out the
It's a pleasure to be here.
The chair wants to recognize you. If somebody up there.
But then one of the comments that I make the motion to waive the reading, adopt ordinance, adding chapter 7.40, addressing marijuana cultivation as a part of the public nuisance in the Union County Ordinance Code.
I'll second it.
I did not hear what he
There's a motion and a second.
We don't know what you're saying.
Someone can read the motion.
Through the chair, I'll read the motion back. The motion was to waive the reading and adopt the ordinance adding chapter 7.40, addressing marijuana cultivation as a public nuisance to Utah County Ordinance Code.
No.
We have a motion and a second. I don't think this is perfect. I don't think this is something that is final or definite. I'm convinced we need more work on this. We need to begin. More than a week or two, it's going to take some time, months. Work on it more as far as I'm concerned. We do have the ad hoc committee of the board already.
To the chair.
Yeah.
The committee is also committed to watching what happens to this grow season and looking at the complaints as they came in last year, compare whatever happens this year. If it gives us new data, fresh data, gives us a little more direction on where we go. We've never said that we are complete and we are done. We've always said we get a start point, we need to start working on it from here. And we said we do it this year, at the end of this growth, that we do it December.
How many people will become criminals because of this?
Before we have any more discussion on that, if I can also insert in the motion that this ad hoc committee will continue till the end of the year.
My understanding that ad hoc committee is continuing throughout the year.
I want it stated on the record.
But I mean, it's separate from the ordinance. It's not part of the ordinance. And my understanding at our April 17th hearing and meeting that we had, that there was a consensus and I believe an agreement and maybe even a motion to continue the ad hoc committee through and to continue on with looking at the issues of collectives and I don't know the second issue. But it's not part of the ordinance. The ad hoc committee is not part of the ordinance, and so my motion has to do with passing the ordinance. if you want to pass or make another motion subsequent to that regarding the ad hoc committee, that's fine, but I mean, my motion has to do with what's on our agenda and what the ordinance calls for.
I don't think adding the verbiage in regards to my request about the ad hoc has any ill effect to the ordinance at all. And last time we met on this issue, we did not have a motion or a second or a vote on this particular issue. So that I have so that I have a sense that this is part of, that this will be on the record, that's my request.
Well, I'm not willing to put out my motion to do that. My motion is, that's what's here in our agenda, and I want to deal with the ordinance itself. I have no problem at all with dealing with your request about the ad hoc committee after that, and I have no problem with continuing the ad hoc committee. I just would prefer to deal with them separately, and because of that, I don't feel like amending my motion.
So council, can I ask you a question in regards to this? Does putting this as part of the motion, does it have anything, is it illegal to do?
It's not illegal to do, however, you would have to agree to amend this motion to allow for that. I am looking at the minutes, it does reference that the board, it was a board consensus, it wasn't a motion.
That's correct.
It was a board consensus was to continue the ad hoc committee to address collective issues and complaint process. So if you want to make that a separate, unless he's willing to.
Or I can amend the motion to include that. I can make a motion to amend the motion to include that. Is that correct?
If you make a motion to amend it, he would have to agree to it. And it sounds like he's not prepared to do that.
No, I'm not, and I would call for the question.
Yeah, well, we have a motion and a second. Let's have a roll call vote on the motion and a second.
Supervisor Vasquez?
Yes.
Supervisor Nicoletti?
Yes.
Supervisor Griego? Yes. Supervisor Avi?
Yes.
Supervisor Stopper?
Yes.
Thank you.
Motion unanimous.
Now I would like some security in regards to this ad hoc committee. So I'm going to make a motion that the ad hoc committee remain intact until the end of the year.
Second. Any discussion? Motion second to continue the ad hoc committee to the end of the year. All those in favor say aye.
Aye.
Anyone opposed? Motion carries. Thank you all very much.